Hello and welcome to Bar10 Test Prep, Lesson 50, where it's our goal to help you prepare for the bar exam 10 questions at a time. To that end, we upload content daily at 8 a.m. Eastern Standard Time. If you like the content, please don't forget to like, subscribe, and click the notification bell so you can be updated every time we upload new content. Let's get going with question number one. Number one. Star who played the lead role in a television soap opera was seriously injured in an automobile accident caused by Danton's negligent driving. As a consequence of Star's injury, the television series was canceled, and Penn, a supporting actor, was laid off. In an action against Danton, can Penn recover for his loss of income attributable to the accident? A, yes, because Danton's negligence was the cause, in fact, of Penn's loss. B, yes, unless Penn failed to take reasonable measures to mitigate his loss. C, no, unless Danton should have foreseen that by injuring Star, he would cause harm to Penn. Or D, no, because Danton's liability does not extend to economic loss to Penn that arises solely from physical harm to Star. Take 10 seconds. Choose your best answer now. If you chose option D, you'd be correct. Remember that in order to prove negligence, you have to show duty, a breach of that duty, causation, and damages. Generally, a plaintiff will not recover for economic loss under negligence if that economic loss does not stem from physical injury or property damage. In this case, Penn suffered neither property damage nor physical injury. The only party injured was Star. Penn would need to demonstrate his economic loss stemmed from his own property damage or his own physical injury in order to recover under a negligence theory. Therefore, Penn cannot recover for his loss of income because Danton's liability does not extend to economic loss to Penn that arises solely from physical harm to Star. Question number 2. Perry sued DiNucci for a libelous letter received by investigator. The authenticity and contents of the letter are disputed. Investigator, if permitted, will testify that I received a letter that I cannot now find, which read, Dear investigator, you inquired about Perry. We fired him last month when we discovered that he had been stealing from the stockroom. DiNucci. The testimony should be admitted in evidence only if A, the jury finds that the investigator has quoted the letter precisely. B, the jury finds or is satisfied that the original letter is in fact unavailable. C, the judge is satisfied that an investigator has quoted the letter precisely. Or D, the judge finds that the original letter is unavailable. Take 10 seconds. Choose your best option now. If you chose option D, the judge finds that the original letter is unavailable, you'd be correct. The best evidence rule deals with the admissibility of writings, where a witness is testifying as to the contents of a writing, and those contents are in fact at issue. The best evidence rule requires that the writing be admitted into evidence unless it has been lost or destroyed, not due to any intentional misconduct of the party seeking to introduce the evidence. A copy is permissible. Here, the best evidence rule requires that the letter investigator received be admitted into evidence because an investigator is testifying as to the contents of that very letter. However, if the judge finds that the original letter is unavailable since the investigator cannot find it, then the letter itself does not have to be admitted into evidence for an investigator to testify as to the contents of that letter. Therefore, the testimony should be admitted in evidence only if the judge finds that the original letter is unavailable. Question number 3. Statutes in the jurisdiction define criminal assault as an attempt to commit a criminal battery and criminal battery as causing an offensive touching. As Edward was walking down the street, a gust of wind blew his hat off. Edward reached out, trying to grab his hat, and narrowly missed, striking Margaret in the face with his hand. Margaret, fearful of being struck by Edward, pushed Edward away. If charged with criminal assault, Edward should be found A, guilty because he caused Margaret to be in apprehension of an offensive touching, B, guilty because he should have realized he might strike someone by reaching out, C, not guilty because he did not intend to hit Margaret, or D, not guilty because he did not hit Margaret. Take 10 seconds. Choose what you believe the best answer is. Now, if you chose option C, not guilty because he did not intend to hit Margaret, you'd be correct. The statutes and the fact pattern define two terms to use in this equation. Criminal assault is an attempt to commit a criminal battery, and criminal battery is defined as causing an offensive touching. In this case, the facts are clear that Edward did not intend to hit Margaret. Rather, Edward intended to grab his hat and narrowly miss striking Margaret's face in doing so. Since Edward never intended to hit Margaret, Edward never attempted to commit a criminal battery against Margaret. Thus, Edward should be found not guilty because he did not intend to hit Margaret at any point. Now, if we look at option A, guilty because he caused Margaret to be in apprehension of the offensive touching, let's look back at the definitions of the crime. Assault is an attempt to commit a battery, and battery is causing an offensive touching. Clearly, there was no offensive touching, and clearly it also seems as well that the assault is an attempt to commit a criminal battery. So if there is no intent to have committed the battery, because the fact pattern specifically tells us what the intent was of the individual, of Edward, then he could not be found guilty as noted under A. B, guilty because he should have realized he might strike someone by reaching out. That is not a legal standard, nor is it required that he realize he might. This is not an issue of negligence. We're not looking at a civil matter. We're looking at a criminal matter. And as a result, generally negligence in taking an action usually does not rise to the level of criminal liability. Or D, not guilty because he did not hit Margaret. While in fact he did not hit Margaret, he could theoretically still be guilty of assault, which is the attempt to commit the battery. So D would not seem to be an appropriate response. C would be the only appropriate response here. Question number 4. Drew was tried for the July 21st murder of Victor. In his case in chief, Drew called as his first witness Wilma to testify to Drew's reputation in his community as a peaceable man. The testimony is A, admissible as tending to prove Drew is believable, B, admissible as trying to prove Drew is innocent, C, inadmissible because Drew has not testified, or D, inadmissible because reputation is not a proper way to prove character. Take 10 seconds. Choose the best answer now. If you chose option B, admissible as trying to prove Drew is innocent, you'd be correct. In a criminal case, a defendant is given the privilege of offering pertinent character evidence about himself to prove he didn't commit the crime. Testimony about a defendant's general reputation in the community is admissible character evidence on direct examination. In this case, Drew was tried for Victor's murder. Wilma is testifying on direct exam as to Drew's reputation in this community as a peaceable man. Wilma's testimony is admissible character evidence because Drew having a peaceable reputation is pertinent to proving Drew did not murder Victor. Thus, the testimony is admissible as trying to prove that Drew is innocent. Option A, admissible as tending to prove Drew is believable. The problem here is that the defendant may likely not testify, so his believability may not come into play at any point. So it's too tenuous. C, inadmissible because Drew has not testified equally. The problem here is that it's not that he's testified or not, and it's not corroborating his prior statements. It's simply stating his character. That would be an independent witness outside of supportive of the defendant's prior statements. D, inadmissible because reputation is not a proper way to prove character. Again, the defendant has every right to present character evidence, and an individual testifying to his peacefulness is a character trait. As a result, would fall into character. Thereby, B would be the only correct answer. Question number 5. Statutes in the jurisdiction define criminal assault as an attempt to commit a criminal battery, and criminal battery as causing an offensive touching. As Edward was walking down the street, a gust of wind blew his hat off. Edward reached out, trying to grab his hat, and narrowly missed striking Margaret in the face with his hand. Margaret, fearful of being struck by Edward, pushed Edward away. If charged with criminal battery, Margaret should be found A, guilty because she intentionally pushed Edward, B, guilty because she caused the touching of Edward, whether she meant to or not, C, not guilty because a push is not an offensive touching, or D, not guilty because she was justified in pushing Edward. Take 10 seconds. If you chose option D, you'd be correct, not guilty, because she was justified in pushing Edward. The rule is that a non-aggressor victim may use non-deadly force in self-defense anytime the victim reasonably believes that force will be used against them. In this case, Margaret pushed Edward because she was fearful of being struck by him while he narrowly missed striking her in the face. Since Margaret's belief that force was about to be used against her was in fact reasonable, she was justified in pushing Edward, and as such, she should be found not guilty. Now, if we look at options A and B, guilty because she intentionally pushed Edward, and B, guilty because she caused the touching, it in fact ignores the fact that here, Margaret was in fact the potential victim, or perceived herself as the victim, and reacted reasonably accordingly. As a result, A and B would not be viable options. C, not guilty because a push is not an offensive touching. That is rather conclusive, and I think that many people would disagree. As a result, I don't think C is a viable response for consideration. As such, only D is the appropriate answer. Question number 6. Wastrel, a notorious spendthrift who was usually broke for that very reason, received the following letter from his uncle, Bullion, a wealthy and prudent man. I understand you're in financial difficulties again. I promise to give you $5,000 on your birthday next month, but you'd better use it wisely or you'll never get another dime from me. Wastrel thereupon signed a contract with a car dealer to purchase a $40,000 automobile and to make a $5,000 down payment on the day after his birthday. If Wastrel sues Bullion for $5,000 after the latter learned of the car purchase contract and then repudiated the promise, which of the following is Bullion's best defense? A promise to make a gift in the future is not enforceable. B, reliance by the promisee on a promise to make a future gift does not make the promise enforceable unless the value of the promised gift is substantially equivalent to the promisee's loss by reliance. C, reliance by the promisee on a promise to make a future gift does not make the promise enforceable unless that reliance also results in an economic benefit to the promisor. Or D, reliance by the promisee on a promise to make a future gift does not make the promise enforceable unless injustice can be avoided only by such enforcement. Take 10 seconds and choose what you think is the correct answer now. If you chose option D, you'd be right. Reliance by the promisee on a promise to make a future gift does not make the promise enforceable unless injustice can be avoided only by such enforcement. When a person does something that nobody asked her to do, that cannot be considered consideration. It can, however, be promissory estoppel. The elements required for promissory estoppel are 1, words of promise, 2, reliance that is reasonable, detrimental, and foreseeable, and 3, enforcement is necessary to avoid injustice. In this case, Bullion promised to give Wastrel $5,000 on Wastrel's birthday, but warned that he'd better use it wisely. Wastrel would likely argue that he detrimentally relied on Bullion's promise when he signed the car contract, because he thought he would receive Bullion's money as a birthday gift when the down payment of $5,000 was due. Whether or not this reliance was reasonable or foreseeable, the last element of promissory estoppel is that enforcement is necessary to avoid injustice. Wastrel clearly did not use the money wisely by purchasing a $40,000 automobile with a $5,000 down payment, so it is hard to see how enforcement of this promise is necessary to avoid injustice. As such, Bullion's best defense is that reliance by the promisee on a promise to make a future gift does not make the promise enforceable unless injustice can be avoided only by such enforcement. Question number 7. Drew was tried for the July 21st murder of Victor. Drew called William to testify that on July 20th, Drew said that he was about to leave that day to visit relatives in a distant state. The testimony is: A, admissible because it is a declaration of present mental state. B, admissible because it is not hearsay. C, inadmissible because it is irrelevant. Or D, inadmissible because it is hearsay, not within any exception. Take 10 seconds right now. Choose your best answer. If you chose option A, admissible because it is a declaration of present mental state, you'd be correct. Hearsay is an out-of-court statement offered to prove the truth of the matter asserted in that very statement. Hearsay is generally inadmissible. A statement that falls within a hearsay exception will be, however, admissible. A hearsay statement of the declarant's then existing physical or mental condition or state of mind is going to be admissible to show that condition or state of mind. An intention is a state of mind. If the statement is admissible to prove the declarant's intention, the jury can further infer action following that intention. In this case, Drew was tried for Victor's murder. William will testify that the day before the murder, Drew said he was about to leave to visit relatives in a distant state. Drew's out-of-court statement to William shows Drew's intention to go out of state to visit relatives. Drew's out-of-court statement constitutes a present state of mind exception to hearsay. Thus, the testimony is admissible because it is a declaration of present mental state. Question number 8. Ben was the illegitimate and unacknowledged child of Fred. Fred died intestate, leaving neither spouse nor any children other than Ben. The state's law of intestate succession provides that an unacknowledged illegitimate child may not inherit his father's property. The spouse, all other blood relations, and the state are preferred as heirs over the unacknowledged illegitimate child. Ben filed suit in an appropriate court alleging that the state statute barring an illegitimate child from sharing in a parent's estate is invalid and that he should be declared lawful heir to his father's estate. In challenging the validity of the state statute, Ben's strongest argument would be that A, there is no rational basis for preferring as heirs collateral relatives and even the state over an unacknowledged child, and therefore the law violates the Equal Protections Clause. B, he has been deprived of property without due process because his fundamental right to inherit has been compromised without a compelling state need. C, it violates the Privileges and Immunities Clause of the 14th Amendment. Or D, it is a denial of procedural due process because it does not give the unacknowledged illegitimate child an opportunity to prove paternity. Take 10 seconds and choose your best answer now. If you chose option A, you'd be correct. There is no rational basis for preferring as heirs collateral relatives and even the state over unacknowledged children, and therefore the law violates the Equal Protections Clause. The Due Process Clause of the Fifth Amendment applies equal protection to the federal government, and the Equal Protection Clause of the 14th Amendment applies equal protection to the states. Equal protection is invoked when a law treats one person or class of persons differently than others. Equal protection provides that all citizens must be offered the equal protection of the laws. Legitimacy classifications are subject to intermediate scrutiny, meaning the law must be substantially related to an important governmental interest. Intermediate scrutiny is more rigorous than rational basis review, which only requires that the law be rationally related to a legitimate government interest. Here, the state's law of intestate succession discriminates against children conceived out of wedlock because an unacknowledged illegitimate child, such as Ben, is not allowed to inherit his father's property. Under this law, the spouse, all other blood relations, and the state itself are all preferred as heirs over an unacknowledged illegitimate child. Legitimacy classifications, such as the state's law of intestate succession, are subject to intermediate scrutiny, as we discussed. If Ben argues there is not even a rational basis for such discrimination, it follows the law will not pass intermediate scrutiny. Therefore, Ben's strongest argument among the answer options would be that there is no rational basis for preferring as heirs collateral relatives and even the state over unacknowledged children, and therefore the law violates the Equal Protections Clause. Question number 9 in this grouping. Jones and Smith, who were professional rivals, were attending a computer industry dinner where each was to receive an award for achievement in the field of data processing. Smith engaged Jones in conversation and expressed the opinion that if they joined forces, they could do even better. Jones replied that she would not consider Smith as a business partner, and when Smith demanded to know why, told him that he, Smith, was incompetent. The exchange was overheard by Brown, who attended the dinner. Smith suffered emotional distress, but no pecuniary loss. If Smith asserts a claim against Jones based on defamation, will Smith prevail? A, no, because Smith suffered no pecuniary loss. B, no, because Jones's statement was made to Smith and not to Brown. C, no, unless Jones should have foreseen that her statement would be overheard by another person. Or D, no, unless Jones intended to cause Smith emotional duress. Take 10 seconds. You're on the right track if you chose option C, no, unless Jones should have foreseen that her statement would be overheard by another person. An allegation of fact in reference to a plaintiff that harms the reputation of that plaintiff by reflecting negatively on a character trait is a defamatory statement by definition. This statement qualifies as defamation if it is published intentionally or negligently to a third person in durable form, libel, or in fleeting form, slander or slander per se. Slander per se exists when the defamatory statement is about a crime of moral turpitude, loathsome disease, sexual misconduct, or adversely reflects on conduct in business, profession, trade, or office. In slander per se, damages are presumed. Jones's statement seems to meet most of the elements to qualify as slander per se. Her statement that Smith was incompetent was an allegation of fact made in fleeting form that adversely reflected on Smith's conduct in business. Whether Jones's statement meets the publication element of slander per se is a little murkier. Brown, simply hearing Jones's statement is not enough. The publication must be intentional or negligent. Since Jones made her comment to Smith during an industry dinner, it may be unreasonable to expect her comment to go unheard by a third person. Thus, Smith will only prevail if Jones should have foreseen that another person would overhear her statement. That is where the answer turns. Final question of this grouping, question number 10. Police were concerned about an increase in marijuana traffic in defendant's neighborhood. One night, police officers accompanied by dogs trained to sniff out marijuana went into the backyard of defendant's house and onto his porch. Defendant and his friend were inside having dinner. The dogs acted as if they smelled marijuana. Police officers knocked on the back door. Defendant answered the door and let them in. Defendant was immediately placed under arrest. After a brief search, police officers confiscated a large quantity of marijuana, which they found in the defendant's linen closet. Defendant's motion to prevent introduction of the marijuana into evidence will most probably be A, denied because the search was incident to a valid arrest, B, denied because defendant permitted police officers to enter his house, C, granted because under the circumstances the police activity violated defendant's reasonable expectations of privacy, or D, granted because the kind of detection by trained dogs has not been scientifically verified and cannot be the basis for probable cause. Take 10 seconds and choose the best answer now. If you chose option C, granted because under the circumstances the police activity violated the defendant's reasonable expectations of privacy, you'd be correct. The Fourth Amendment prohibits unreasonable searches and seizures. Unreasonable searches and seizures have been deemed to be those involving state action which intrude upon an individual's reasonable expectation of privacy. The purpose of the Fourth Amendment is to prevent police and law enforcement misconduct. An individual has a reasonable expectation of privacy in the immediate area surrounding the home, but not in the open fields surrounding a home. If a defendant's constitutional rights are violated in connection with a criminal prosecution, the Exclusionary Rule requires the exclusion of all evidence obtained in violation of such rights and all derivative evidence. In this case, police officers violated defendant's reasonable expectation of privacy in the immediate area surrounding defendant's home by going on to defendant's porch without a warrant or a valid exception to the warrant requirement. Per the exclusionary rule, the marijuana obtained in violation of defendant's reasonable expectation of privacy will be excluded from evidence. Therefore, defendant's motion to prevent introduction of the marijuana into evidence will most probably be granted because under the circumstances, the police activity violated the defendant's reasonable expectations of privacy. As always, thank you for joining us on Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. To that end, we've uploaded this content as well as content every day at 8 a.m. Eastern Standard Time. Please like, subscribe, and ring the notification bell so you can be updated every time we do upload new content.